Hello friends, today we are going to study about the fundamental rights that is enshrined in part 3 of the Indian Constitution. So let us begin with the introduction. Part 3, Part 4, Part 4a, though separate units concretize the lofty goals of justice, liberty, equality, fraternity and the dignity of the individual set out in the preamble. So let me tell you that part 3 denotes fundamental rights, part 4 denotes DPSP, and part 4a denotes fundamental duties. Imbued in the dominant theories of human rights, we may generally classify these parts respectively as negative obligations of the state not to interfere with the liberty of an individual, positive obligations to take steps for the welfare of the individual, and the duties of an individual to society and few individuals. Article 12 in Indian Constitution gives the definition of state, includes government, parliament, state legislature, all local authorities inside India and outside India. I mean the authorities that are outside India, which include the Indian vessels that are traveling to foreign countries through the sea, which are outside obviously the territory of India, and the Indian embassies and military establishments outside India also are incorporated in it. And to talk about negative and positive obligations, let me tell you that suppose you're walking in the street, can any policeman come to you and tell that from this day there is a law that you can't walk in the street? In the street you can't walk? No, he can't tell that, because if he tells that it will be sounding like a draconian law, and in India it is not allowed. So that is what we call as negative obligation, that the state cannot intervene into the liberty of an individual. The state can also not intervene into the private life of an individual, that also is included in his liberty. And the positive obligations, when you talk about positive, there is obviously something good coming. So we are talking about to take steps for the welfare of the individual. I mean, when the state gives free education, when the state gives free health aid, it is like positive obligations, right? Because it is trying to establish a welfare state. The duties of an individual to society and few individuals, we are individuals here, just like Modi has renamed the King's Way as Kartavya Path. That reminds us that we also have some duties to the state, to the other individuals, and to ourselves also. So, therefore, the duties of an individual to society and few individuals means we also have some duties that can be taken as a positive obligation, because obviously to perform good duties, I mean good duties, I'm terming it as good duties, is a positive obligation and is a positive manner of behavior as well. And thereafter, if we go further, as per Article 13, which denote laws inconsistent with or in derogation of the fundamental rights are to be null and void by the judiciary. All laws in force in India immediately after the commencement of the constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent be null and void. That means whichever laws there are which are contrary to the provisions of the fundamental rights are to be declared null and void. And the laws, when the constitution came into force, prior to that the British laws that were made, which were in derogation with the fundamental rights, derogation with the fundamental rights, were to be declared null and void immediately after the commencement of the constitution. The state shall not make any law that abridges any right mentioned in the part 3 of the constitution. I don't think there is any need to elaborate this topic. As article 13 as per article 13, the definition of law includes ordinance, order, bylaw, rule, regulation, notification, custom, usages, laws made by the legislature or any authority competent. Here in bracket there is written comp, that means competent, in entire country or in a particular area. That means law, that means as per article 13, law includes all these elements. These elements are to be declared as law as per Article 13. The article is not competent to impact the process of Article 368. That means this article shall not impact the process of Article 368. That means nothing in this article shall apply to the procedure of Article 368. The Article 368 and Article 13 are two elements which are inversely proportional to each other, you can say, or which have some mismatch between each other. That means Article 368 is not much of an issue to impact the changes in the laws of Article 13, right? If I'm not wrong. Thank you. Jai Hind.